The speaker for today's session is Dr. Anish V. Pillai. Dr. Anish V. Pillai is a faculty of law at the School of Legal Studies, Cochin University of Science and Technology, Kerala. Prior to joining SLS, he has worked as a faculty of law in Hidayatullah National Law University, Raipur, Chhattisgarh. He has been awarded PhD from CUSAT, Kerala, India. He has also qualified the state eligibility test for law in 2013. He has been awarded the prestigious Distinguished Young Faculty Award 2017 to 18 from Cochin University of Science and Technology, Kerala. He is also the recipient of prestigious Professor Dr. A.T. Marcos Memorial Gold Medal from Cochin University of Science and Technology for securing first rank in LLM. He has participated in numerous international and national conferences, workshops, and training programs, including the IUCN funded the Trainers Program held in Colombo, Sri Lanka, International Conference held at Dhaka International University, Bangladesh, International Consumer Protection Conference held at University of Pretoria, South Africa. He has delivered several invited lectures at institutions in and outside India, including the University of Chittagong, Bangladesh, National Yunlin University of Science and Technology, Taiwan, Federal University of Bahia, Brazil, and many more. Now I will be handing the session over to Sir. Sir, over to you.
Thank you. Thank you so much for the words of introduction. Can I share my screen?
Yes, sir, sure.
So I hope my screen is visible.
Yes, sir.
So, well, friends, yesterday you had a nice introduction about Indian competition law framework. I have seen very eminent speakers where delivered lectures. So today I will be speaking about regulation of mergers under Indian competition law. Now, when I was supposed to send a topic for this FDP, purposefully I have selected this topic. The reason is, being a competition law teacher, I find it very difficult to understand the law relating to mergers, how competition law regulating mergers. I feel this is one of the most hardest part in our Indian competition law. So that's why I thought I will make an attempt to explain very simply how the mergers being regulated by Indian competition law. Let's start. We all know we need a perfect market. A perfect market wherein maximum number of sellers, maximum number of buyers, and a very good competition is going on, or perfect competition is going. So that is what beneficial for both consumers as well as the country. So to ensure that in a market, perfect competition is going on, Indian legislatures introduced competition law. And yesterday, Vijay Umar sir might have explained to you how this law came into force and what are the reasons behind that. So I'm not touching all that things. But I will tell you, competition law of India primarily dealing with three important aspects. We can say three pillars of competition law. One is regulation of anti-competitive agreements. Second pillar is regulation of abuse of dominance. And the third pillar is regulation of combinations. In fact, when I am talking about mergers and its regulation, I will be talking about combinations because merger is considered as a combination by competition law. So whatever I will be talking, that is based on regulation of combinations because the regulation is same as that of merger. Okay, so we will focus only on combinations. Now, if you go through Competition Act 2002, you will find Section 5 because Section 5 is the major section which is relevant for us, wherein the role of Competition Commission to deal with mergers are mentioned. If you see Section 5 is talking about combinations. Now, what is combinations? As per Competition Act, combinations can be of four different types. One is acquisition. Second is takeover. Third is merger. And fourth is amalgamation. Now, those who are teaching or those who are studying commercial law, you will find it all these four terminologies are four different things. Because acquisition and takeover are two different things. Merger and amalgamation are also different things. So for those who are having expertise in commercial law or commercial sector, they will consider these four terminologies are four different things. But when it comes to Indian competition law, we will consider merger and amalgamation are same. We will not distinguish between merger and amalgamation because the law uses the term or the section uses the word merger or amalgamation. So whether it is merger or amalgamation, whatever be the nomenclature, that is irrelevant for us. That is competition. Same case with acquisition or takeover. So acquisition and takeover is considered as one and same by Competition Act. So that fact you have to understand. So when I am talking about merger, I will be talking about merger or amalgamations. Okay. Now, why mergers or why these combinations? Those who are already studied or already in the field of law, you might be knowing why mergers are happening in the market. There are several reasons for going for a merger. Every time we will hear this company merge with that company, like that, we will hear. So what are the reasons for mergers? The first reason is growth. Every country, every company, or every firm looking for growth. So how they can expand? By joining together with similar nature of activities or similar nature of companies. So by joining with others, you can grow. That is one reason. Second is when you join together, you will be able to pool your resources. And that pooling of resources will ultimately lead to improvement of quality. If you are in the field of a product, you may improve the quality. If you are in the field of a service, you may improve your quality. So that is second reason for going for merger. Now the third one is access to technologies. Now A and B both are competing each other, but they are operating in the same field. Maybe they may be operating in a different field, but still each one of them have their own patents, their own technologies. Now, if A and B, instead of competing each other, if they will join together through merger, they can share their technologies. And that joining or sharing of technologies will have a huge impact in the market. So obviously, companies with the good technologies, other companies will be ready to merge with them so that they will get that access to technology. So that is another reason. Then facilities. Obviously, when a company is joining with another company, if they are having larger facility, larger supply chain or production chain, definitely the companies joining together will have an impact. Then entering into the different markets, like a soap manufacturer is merging with a paste manufacturer, toothpaste manufacturer, then obviously the soap manufacturer can enter into a new market through this way of merger. So that different market, entering into different market, that is another reason. Then geographical location, like a South Indian company is merging with a North Indian company, so that both the geographical area they can have business. So these are all some of the prominent reasons for going for mergers in the larger perspective combinations. Now, quickly I will tell you these combinations, as I said, there are four things. One is acquisition, another is takeover, then merger, then amalgamation. Now, acquisition is defined under the Act. Those who are interested, you can have a look. Section 2A defines acquisition. And we have a semi-code on acquisition that also defines what is acquisition. Then takeover. There is no definition for takeover as such, but in commercial world, you will get a definition. Just for the namesake, I have included. Now coming to our merger. Interesting thing, our Competition Act 2002 does not define what is merger. Now, what is merger? Those who are teaching, those who are studying, definitely knowing that when two or more entities combine into a big entity, 1 plus 1 is equal to 1, or 1 plus 1 is equal to 2, or A plus B is equal to A, or A plus B is equal to B, or A plus B is equal to C. So in any form, when two or more companies or entities joining together, the resulting product or resulting firm, that is what the merged firm. So that is what merger. Now, as I said, there is no definition for merger provided in the act. Now, can you tell me whether this term merger is defined in Indian law, in any of the Indian law? Can anybody tell me whether merger is defined in any of the Indian law? Somebody can tell me, because you are all teaching this subject or interested in this subject, might have studied or heard somewhere. The term merger is legally or statutorily defined in India.
No, it is only the demerger which has been defined under the Income Tax Act.
Yeah, you will get a clue in Companies Act. You can see in the screen, Section 232 explanation 1 provides a clue what can be, but that is also not a proper definition of merger. But interestingly, if you go through Income Tax Act, Section 2(1)(a), it defines amalgamation. So we have a statutory definition for amalgamation. Now, what is the definition for amalgamation? Amalgamation as the major merger of one or more companies. So why I am referring this definition? Amalgamation is the merger of one or more companies. So merger is amalgamation according to Income Tax Act. And in Competition Act also, we are not going to distinguish between a merger or amalgamation. So this definition you can consider to an extent for the purpose of giving a statutory definition for merger. Other than that, in India, we don't have a merger definition. Now, as I said, merger and amalgamation is considered as one and same by competition law as well as Income Tax Act. But in commercial world, there are some differences. Like one of the slight differences in merger, a new name will happen. Like A plus B is equal to C. And in amalgamation, A plus B is equal to either A or B. So whenever there is a joining of two or more companies, the resultant company will be totally a new company. That is what commercially, in commercial world, that is what indicated by merger. And when it comes to amalgamation, when two or more firms merge together or join together, there will be a resulting party will be either A or B. So that slight difference is there in the commercial world. So that is what merger. I think that is clear. What is merger? Now, as per our commercial practice or practice in the country, merger can happen in two different ways. Either through absorption, that is one company absorbing another company. For example, Tata Fertilization, Tata Fertilizers Limited, TFL, they were absorbed by Tata TCL. So TFL was absorbed by TCL. It is a way of merger through absorption. Now, second method is consolidation. They are joining together. For example, merger of Hindustan Computers, etc., with and they become a new company, HCL. So that is a way of consolidation. So merger can take place in two different ways. One is through absorption and another is through consolidation. Okay. Now, based on the entities involved in merger, we can classify mergers into three categories. What is horizontal merger? Horizontal merger. Here, in horizontal merger, the competitors are they are the same market, like manufacturer, seller, producer, distributor. They are in the same supply chain, same level of supply chain, and they are competing each other. So when merger happens between these two, we can say that is horizontal merger. Now, vertical merger, that is merger between two or more entities in a different level of supply chain. Like a producer is merging with a supplier is merging with distributor, distributor may be merging with seller, something like that. So they were in the different level. Now there is the third method is code-generic merger. Code-generic merger. Here, it is a case where the companies merging together are not in the same field of operation or same market. Like a manufacturer of rice is merging with manufacturer of a soap. Both are two different things. Two different things. Now, conglomerate merger. Here, it is a merger between entities which are not linked or connected in any form. Like the example which I gave, that is an example for conglomerate. That is a rice manufacturer or a catering company is merging with a toothpaste company. They are nowhere related to each other. Now, when it comes to code-generic merger, they were in the larger market, but their products are different. Say, for example, two companies. One company is involved in manufacturing of soap. Another company is involved in manufacturing of shampoo. Now, both are in the same market of cosmetics or personal hygiene. That is, their products are somewhere related, though their operations are totally different. But when it comes to conglomerate merger, the merging parties having no connection at all. Even in the larger perspective, they were not in the same market. Like a catering company is merging with the airlines company, or an airlines company is merging with a banking company. So that is what conglomerate merger. Very rarely this conglomerate merger will happen. Now, being said, what is merger and how merger takes place and what are the types? Now we can look into Indian law. Under our Indian Competition Act, we have sections 5, 6, 20, 29, 30, and 31. These are the sections dealing with mergers. These are the sections. And these provisions were notified and it came into effect from 1st June 2011. The Competition Commission started functioning from 2009. These provisions relating to combinations came into effect only from 1st June 2011. To facilitate the regulation of mergers and other combinations, Competition Commission has issued a regulation. You can see the title of that regulation. That regulation also published in 2011. Now, why competition law regulating mergers or in larger perspective, combinations? There are 2-3 reasons behind that. Why competition law or competition commission is interfering with mergers? Because prior to 2002, or even now, when we say mergers, people will say it is an aspect of company law. Why competition law is interfering with mergers? That question always comes into picture. The major reason is unilateral effect. Like we know in every market, certain manufacturers having strength. Say for example, Pepsi company in soft drink market, Pepsi company having a very good market share. Same case with Coca-Cola. Now, if they join together, they will get a monopoly in the market. If they merge together, they will get a monopoly in the market. So that unilateral effect is always looked at with suspicion. Because of merger, the resultant entity will be strong in the market. They will achieve maximum market strength. And that market strength is considered as very suspicious because they can very well cause harm to market competition as well as they can harm the interest of consumers as well as the national economy. So that is one of the reasons why by which CCA is or competition law is interfering with mergers. Second reason is coordinated effects. Coordinated effects. When two or more companies will join together, they can do so many activities jointly. Previously, they were competing each other. But now, once they merge together, they will do the activities together. That coordinated effect also is looked at with suspicion because they will get maximum market strength in the market, and that will be considered as something very suspicious for effective competition in the market. So these are the two important reasons for regulating mergers. Now, other than that, in case of horizontal merger, that is a merger between companies of same standing, that is two competing manufacturers are merging together. That is always considered as bar to competition in the market. As I said, Pepsi and Coca-Cola is merging together. That will cause harm to software market, soft drink market in the country. So that horizontal merger having that problem. But when it comes to vertical mergers, that is a manufacturer is merging with a seller or a retailer, it is not that much considered as harmful, or it is not looked at with suspicion. So these are some of the reasons why competition law is interfering with mergers. Now, when I am saying competition commission or competition law can regulate mergers, it is not the case each and every merger happening in the country will come under competition. To consider or to regulate a merger, that merger should be a combination. When a merger can be treated as a combination, that criteria is provided in Section 5 of the Act. So only those types of mergers which satisfies the criteria mentioned under Section 5 will be treated as a merger for the purpose of regulation by competition. So remember, each and every mergers happening in the country will not be interfered by competition. Only those mergers which qualifies as combination by satisfying the criteria of Section 5 will be treated as mergers for the purpose of competition law. Now, what are those criteria? That criteria are based on the asset value as well as turnover. So competition law says it is the threshold of asset as well as turnover. Now, there is a different asset value and turnover is prescribed based on the parties involved in the mergers. I'll just tell you how it is. If both the parties involved in mergers are Indian companies and individual companies, okay, both the parties are Indian companies. Individually, both the companies must have rupees 2,000 crore or above asset value they must have. So A and B wants to merge. Both are Indian companies. If their asset value, total asset value is less than 2,000 crore, competition law will not interfere with that mergers. Clear? So competition law will interfere with only those mergers where asset value will go more than 2,000 crore. Now, either asset value or turnover. Now, 6,000 crore must be the turnover together. Then only that will be treated as a. So either of the criteria has to be satisfied, either the asset value or the turnover. So all those mergers which does not satisfy this asset value or turnover will not come under the scanner of competition. Secondly, if it is a group merger, then the asset value is 8,000 crore. Together, the total asset value must be 8,000 crore. And the turnover must be 24,000 crore. So either of this criteria should be satisfied. Otherwise, that merger will not be treated as a combination. So that CCA will not interfere. Now, there is a possibility Indian parties or Indian firms may merge with a foreign company. If that be the case, if it is individual merger, then their asset value must be 1 billion US dollar. And in that, minimum 1,000 crore should be within India. Now, assume a situation, a company having only 100 crore in India is going to merge with a US company having 1 billion US dollar asset value. That merger will not covered under competition. So competition law will interfere with the merger if minimum 1,000 crore asset must lie within India. And together, all over wherever they are functioning, together they must have 1 billion US dollar. Now, if it is turnover, then 3 billion US dollar. 3 billion US dollar. And in that 3 billion US dollar, minimum 300 crore must be within India, the turnover. Then only that merger will be covered under Indian competition law. Likewise, if it is a group acquisition, the total asset value must be 4 billion US dollar. In that, minimum 1,000 crore asset must be within the territory of India. And if you are looking at the turnover, 12 billion US dollar will be the turnover, annual turnover of that companies. In that, minimum 3,000 crore must be within India. Then only that type of merger will be regulated by CCA. So Indian competition law does not regulate each and every mergers. That is a primary fact you have to remember. So Indian competition law regulate mergers only if it satisfies the threshold based on the asset as well as turnover satisfied. Clear? I think that is clear. Now, how the asset value will be determined? Section 5 explanation C provides a guideline how asset values of these companies can be determined. That is very easy process. Anybody can read and understand. Now, interestingly, if you go through the various provisions of Competition Act, even when a merger satisfies the threshold limit, even when a merger is considered as a combination as per Section 5, competition law will not regulate that. That means there are certain exceptions. So these exempted categories of mergers will not be regulated by competition. Competition law will not interfere with this type of mergers, even though it comes under Section 5. Okay. That exemptions are specifically provided in Section 6 Clause 4. The first exemption is provided in Section 6 Clause 4. Now, around 11 types of mergers were excluded as per Schedule 1 of Combinations Regulations 2011. 11 types of mergers were excluded. Then CCI can, through notification, exempt any type of mergers from the purview of competition. So you can see earlier, merger between banking companies were excluded from the purview of competition law from 2013 to 2018. But now that exemption is not there. Then another exemption is de minimis exemption or target exemption. CCA will issue regulations or notifications. Through that, they will prescribe a value, a target value. If the merging firm satisfies or goes below that target value, then they will be exempted from competition law. Competition law will not interfere with their merger. Then finally, there is a situation of group exemptions. Certain things are exempted. So you will get all these details in the Competition Act as well as the regulation. I will not tell you all the details, but just go through the combinations regulation. You will get which are the categories of mergers which is excluded in our country. Yeah. Now, as I said, government can notify through notification, they can exempt any type of mergers. You can see amalgamation of regional rural. That type of mergers were excluded through a notification from 2017 to 2022. Now, reconstitution, transfer, and amalgamation of nationalized banks, that is specifically excluded from 2017 onwards. So that exception is still in force. Then banking companies, their mergers were exempted from 2020 to a 5-year period. So up to 2025, that type of mergers will not be covered under competition law. Then combinations involving central public sector enterprises. That exemption was there from 2017 to 5 years. That is up to 2022. Now, de minimis exemption. See, this is the criteria prescribed for claiming de minimis exemption. If your asset value is less than 350 crore or your turnover is less than 1000 crore, if the target enterprise is in India and they are having an asset value in India less than 350 crore or a turnover less than 1000 crore, then such type of mergers are exempted. Such type of mergers will not be regulated by competition. I think that is clear, which are the types of mergers that is covered under competition law and which are excluded. Now, Ministry of Corporate Affairs also issued certain notification. Through that, they have also made certain exceptions. You can see a notification, the relevant notification is issued on 27th March 2017. So that notification is available. Anybody can read that. So now we have come to, we know what are the types of mergers covered under competition. Once it is clear whether a particular merger is a combination and it can be regulated by CCA, next question is how we are going to regulate, how CCA is going to regulate combinations or mergers. Now, when we think about regulation of mergers, section 6, 20, 29, 30 and 31 are the charging sections. So if you read these many sections, regulation of merger is very easy. Anybody can understand very easily. Now, as per section 5, nobody should enter into any combination which is having an appreciable adverse effect on competition in the market. So there is an express prohibition that no party or no enterprise in India should go for merger if it is having an appreciable adverse effect on competition in the market. Now, we know why that apprehension is there. As I said earlier, coordinated effect as well as unilateral effect. After the merger, it may cause some apprehension whether it will interfere with market competition or not. That is why we are going to regulate. Now, before starting regulation of any combinations or mergers, one of the fundamental question is, what is the relevant market of that firms? Because appreciable adverse effect on competition or likelihood on competition, adverse effect on competition can be determined only if you know relevant market. That is in which market this particular entity or merging participants in the merger is going to function. So determination of relevant market is one of the key steps prior to starting the regulation. Now, how you will identify a relevant market? I think somebody might have said to you, discussed with you yesterday, what is relevant market. If not, somebody will discuss again in the coming sessions. Anyway, so relevant market can be determined based on two things. One is relevant product market and another is relevant geographic market. And you can find definitions in section 2 clause R, 2 clause S and 2 clause T. So it's simple. Relevant market, that is RM, is equal to relevant geographic market. That is the geographical area where this firms having operation. Plus RPM, that is relevant product market. That is, in which product market these firms are functioning, or which service market these firms are functioning. So based on relevant product, relevant geographic market and relevant product market, CCA can identify what is the relevant market of this merger. Once relevant market is determined, then the next question is whether this particular merger having any adverse effect on competition. That can be determined based on section 20 clause 4. So section 20 clause 4 will give you the criteria to determine whether a merger having any appreciable adverse effect on competition in the market, in the relevant market. So I think that is clear till now. So the regulation starts with determination of relevant market. Once relevant market is determined, next question is whether it is having any appreciable adverse effect in the relevant market. For that, section 20 clause 4 provides various criteria. You can see in the screen like actual and potential level of competition, extent of barriers to entry into market, level of combination, degree of countervailing power, etc., etc., etc. So these are the criteria. Using this criteria, the CCA will identify whether that merger having any appreciable adverse effect on competition. Now, not many criteria are there. I am not explaining that. Now, why this is actually whenever there is a merger, what CCA has to do is CCA will do determining the relevant market, and secondly, they will identify whether that merger having any appreciable adverse effect. If there is appreciable adverse effect, CCA will go for decisions or they will issue orders. That is very easy task, and theoretically that is what actually happening. But in practice, regulation of mergers having different step. So those who are interested in teaching this particular area, you can note down very simply certain steps are there. If you note down these steps, you can easily understand how merger regulations will happen in India. Though it is very complicated, I will tell you certain steps and you can remember that stepwise. So step 1, that is initiation of regulation. How a merger regulation can happen. A merger regulation can happen either through pre-merger notification. As per section 6 clause 2 of Competition Act, every company or every firm or every parties in a merger, prior to finalizing the merger, have to give a notice. That is pre-merger notification to CCA. That was a mandatory thing. And if you violate that, there was a penalty for that. But interestingly, Ministry of Corporate Affairs, through a notification in March 2017, suspended this particular procedure. That is, even though section says parties has to give a pre-merger notice, as of now, it is not in force because that particular procedure is suspended by MCA up to 2027. Then, second method of initiation of a merger regulation, that happens through information. Information in the sense, somebody aggrieved by the merger will file a case, or somebody purposefully file a case before the CCA. That is the provision provided. That for that provision is there in section 20 clause 1. Now the third method of initiation is suo motu. CCA will investigate by its own knowledge. So merger regulations under Indian competition law happens or starts with either of these three methods: through a pre-merger notification, through an information given by an informant, thirdly by its own knowledge. Clear? That is the first step. Now, as I said, section 6 clause 2, which mandates that a pre-merger notification has to be issued. But now that notification is... So what I was saying is, pre-merger notification was mandated in section 6 clause 2, and those who are failed to give notification prior to going for merger, there was a penalty that was provided in section 43 capital A. But fortunately, this procedure is now suspended through a corporate affairs notification till 2027. Now, this pre-merger notification is also made as optional for certain companies or certain types of mergers through this 2011 regulations. So pre-merger notification was there as per section 6 clause 2. Now, one optional option is given to certain types of merger as well as it is suspended by MCA now. Now, those who are not filing this notice or those who are not giving this pre-merger notification, as I said, as per section 43A, there is a penalty. And there were cases where penalty was imposed also. You can see the case like Johnson & Johnson, that case, then they made a delay in filing the pre-merger notification. And another case is Pyramid Enterprise Limited. In that case, they did send the pre-merger notification. And CCI imposed a 5 crore rupee as the penalty. Now, information. As I said, the second method of initiation of a merger regulation is through information. Section 20 clause 1 provides the provision for that. Then suo motu. Now, once CCI decides to investigate about a particular merger, then the second steps will come. In the second step, CCI will look or CCI will examine whether the alleged merger is a combination under the Act. There, CCI will apply the threshold limit prescribed in section 5. So by applying section 5 threshold limit, CCI will identify whether this particular merger is a combination. If they comes to the conclusion that it is not a combination, it is not satisfying the threshold limit, then they will dismiss the investigation. If it satisfies, then they will continue with the investigation. Now, in this stage, CCI will look into another fact, that is, whether it satisfies the threshold limit, and even if it satisfies the threshold limit, the next question is whether it is an exempted category of merger. If it is an exempted category of merger, then also CCI will close the matter. So these two things they will do in step 2. Now comes step 3. In this third step, CCI will form a prima facie case. If CCI will come to the conclusion that there is no prima facie case to proceed against a particular merger, they will close down the case. But if they formed a prima facie case that there is a reason or there is a need to investigate about this particular merger, then they will go for investigation. So in the third step, CCI will form a prima facie case or prima facie opinion. Now the fourth step, regulation. So here, the CCI will see once there is a prima facie case for investigation, then they will go for investigation. The procedure is mentioned under section 29. Now how they will start? The procedure will start with a show cause notice. They will issue a show cause notice to the concerned parties. And the concerned parties has to give a reply within 30 days of receipt of the notice. Now, along with this notice, CCI will also direct Director General to investigate about the functioning of that merger or after effect of that merger or the consequences of that merger. And CCI will prescribe a particular time limit, so within which DG has to, that is Director General has to investigate and submit the report. While DG will investigate against a particular merger, they will use the criteria provided in section 20 clause 4 for the purpose of identifying appreciable adverse effect on competitions. So based on that, DG will submit his report. Now, during this process, If CCA feels that the parties has to give more details, then CCA can direct the concerned parties to publish more details. Then, if they want, they can ask any stakeholders to submit their responses. Because once the details about merger is being published, there may be some other interested stakeholders. So interested stakeholders can very well submit their response. For that, 15 days time will be given. Now, even after that, if CCA feels that some additional information is required, they can ask that additional information from the concerned parties. Now, after receiving all informations, within 45 days, CCA will issue the order. CCA will issue the order. So it's a very simple step involved in investigation of a particular merger. So a show cause notice will be served, and also a direction to DG will be given. DG will submit his report after applying the criteria. Then additional information can be sought. Then finally, CCA will issue the order. So very simply, step 4 will happen. Now, this is what I said with respect to a direct complaint. Now, even when there is a pre-merger notification, the same procedure will be followed. Now, once everything is done, investigation is over, CCA will make orders. That is the step 5, orders. Section 31 provides what are the various orders CCA can issue. Now, either CCA can approve it, whatever proposal for the merger is there, they can approve it. It is well and good. There is no need of any change. Now, if CCA comes to the conclusion that this particular merger will adversely affect competition in the market, then they can reject the proposal. If the CCA feels that a modification will reduce or eliminate appreciable adverse effect on competition, then CCA can issue an order for modifying the proposed merger or the plan of merger. So either approval or rejection or modification. Either of these 3 orders can be given by CCA. Now, these orders, generally in competition law, we classify into 2. One is structural modification, structural remedies, another is behavioral modification. Structural remedy in the sense, some modification in the arrangement of merger. Behavioral remedy in the sense, once you go into merger, once you merge, your behavior will be controlled. Certain restrictions will be imposed on your behavior. So that way, structural or behavioral remedies will happen. Now, interesting thing, once an investigation starts or once a pre-merger notification is submitted before the CCA, CCA has to complete its investigation and pronounce the order within 210 days. So if there is a delay on the part of CCA in approving or rejecting or issuing an order of modification, after 210 days, it will be considered that there is a deemed approval. So if there is any delay on the part of CCA in providing an order, that will be treated as deemed approval. So 210 days is the maximum time limit within which CCA has to wind up their investigation and issue the order with respect to mergers. So this is the way in which competition law in India regulates mergers. Now, if any party having any grievance regarding the order given by CCA, they can go for appeal. Earlier it was Competition Appellate Tribunal. Now we can go for appeal to National Company Law Appellate Tribunal, NCLT. Okay. Section 53A provides the provision for appeal that has to be dismissed. That appeal has to be disposed within 6 months. Now, in 2019, CCA has introduced a new procedure through its regulation, that is Competition Commission of India, procedure, etc., business related to competitions, regulations. A green channel approval, that is an automatic approval of competitions. This regulation prescribes certain conditions. If your merger satisfies that conditions, you will be treated as deemed to be approved by CCI. So those who are interested to know more about this, you can go through this procedure, this regulation, and that regulation will give you more details about green channel filing. So it's a green, it will be a deemed approval to make the approval process very easy. Now, the criteria is also mentioned in the regulation in which type of mergers can go for green channel approval. Now, there is a possibility of cross-border merger, especially our Companies Act allows cross-border merger. So there is a possibility of cross-border merger. Now, the law is same, the procedure is same, as I said, sections 5, 6, 20, 29, 30, 31. As well as this, combinations, regulations of 2011 will be applicable to that. Now, one interesting question always people will ask, if a combination takes place outside India, whether Indian competition law having any control over it. Though we haven't interfered with that type of things, but still, if there is a combination or a merger happens outside India without any Indian participant, still Indian competition law can interfere with that. That is because of Section 32. Section 32 of Indian Competition Act provides for extraterritorial application of competition law. Extraterritorial application of competition law. Now, when CCI can interfere, if that merger having an adverse effect in India, so we follow effects doctrine. Even though the participants are from different countries, Indian parties are not there, but if there is an effect on Indian market, Indian Competition Commission can interfere. But the question is, to what extent CCI can effectively regulate such type of mergers? Because the participants are from different country. So that question remains there. But otherwise, theoretically saying, CCI can interfere with a combination or a merger happening outside India. Now, take the examples where Indian Competition Commission has did something with some foreign mergers, like Tata Steel Limited. They concluded a merger deal by acquiring Anglo-Dutch Steel Company, Chorus Group PLC in 2007. Like that. But all this happened outside India. Still, CCI has made their own intervention there to ensure that these type of mergers will not have any appreciable adverse effect on competition in the Indian market. This Hindalco novels, that is also another example, where in the other companies, other countries, firms were indulged in merger, but Indian Competition Commission were interfered. Now, what problem will happen when Indian competition law regulates cross-border merger? Conflict of jurisdiction. Like, suppose a merger takes place in US or in England, their concerned authority may give approval for it. But Indian Competition Commission may say no. So there's a chance of conflict between two regulators. But to avoid this conflict, if you see Section 18 of our Competition Act, Section 18, it gives the authority to CCI to enter into MOUs with concerned regulators in other countries. So if Indian Competition Commission can enter into MOUs with other concerned competition authorities in the world, whenever an issue happens, Indian Competition Commission can operate through that concerned competition authority or concerned authority there exists in the country. So that way this problem can be avoided with respect to cross-border merger. So these are the way in which merger regulations happens in India, or these are the way in which Indian competition law regulate mergers. Now, when we talk about this merger, four issues generally comes into picture. What I already said with respect to cross-border merger, that is conflict of jurisdiction, etc., and practical difficulty. And that practical difficulty and conflict of jurisdiction issue can be very well avoided through MOUs with corresponding agencies. Now, the next problem is regarding 210 days delay. Sometimes this 210 days may go beyond that. So people generally say in commercial world, things has to happen very fast. So you can go for green channel approval. And even when 210 days is there, if you are already giving all the relevant documents, it may take only maximum 210 days. Within that, you will get that exception. You will get an order. Then another problem is tussle with sectoral regulators. In India, we know we have several sectoral regulators like under company law, TRI, etc. Now, when company law approves a particular merger, Competition Commission may interfere there and say no. So that is a problem which is presented by most of the jurists or most of the people practicing in this field. They always say if competition law interferes with mergers, that may interfere with other sectoral regulators. Now, I would say that apprehension is wrong, because when companies act or under companies law, if a merger is approved, they will never look into the aspect of how this merger will affect competition in the market. And what CCA is looking? CCA is looking only to the extent whether this particular merger having any adverse effect on competition in the market. So there is no apparent conflict between sectoral regulators because their objective of regulation is different. Their objective is different. So there is no chance of tussle between sectoral regulators. Then the final point is central government's power to exempt. Some of the writers used to criticize that since central government is vested with the power to exempt any category of mergers from the clutches of competition law, that is not good. Even that also, I don't think that's a big issue. Why? Because central government will make a decision based on based on the situation arise, based on the circumstances and need of the market. So based on the need of the market, if government feels a particular type of merger can be accepted, they can accept. And I don't think even now, whatever exceptions are there provided by central government, we cannot criticize that type of exception. There are reasons behind giving exceptions. So simply, since central government having a power to accept, we cannot criticize that. So these are the issues raised, or these are the issues highlighted by writers with respect to mergers. So by this, I would like to conclude my discussion. And if you have any doubt regarding any aspect which I discussed, I'm happy. We have 10 minutes. We will discuss. Thank you.
Thank you so much, sir, for your insightful words. As sir said, we are now open to questions. If anybody have any questions, you can please ask them.
Good afternoon, sir. My name is Rupendra
Yes,
Singh. Sir, if we see, can you just put some light with reference to the 2023 amendment which has been suggested?
Camera on, karo, Rupender. It doesn't look nice. If you ask a question and not camera on, it's not.
Good afternoon, sir.
Yeah.
My name is Rupendra Singh.
Yes,
Can you just throw some light with reference to the 2023 amendment which has been proposed with reference to the combination? Particularly, they have come up with the terminology DVT, a deal, value-based deal transaction, something. So if you can put some light on that aspect.
See, two things I have missed out in my discussion. Purposefully, I left out. One is I haven't discussed any practical scenario. The reason is very simple. You have a specific session by CCI member. So one of the CCI member will be discussing about regulation of combinations. So definitely he will be talking about practical scenario, how recent cases were done. So he will explain that. So I have it included. And second thing regarding this amendment. Now this amendment is a proposed amendment. I'm not that much aware of, or I'm not that much, I don't have the expertise to evaluate now. Once that amendment takes into place, then we will be able to talk. Because it's a new concept introduced by the CCI. And even in the academic field, people having different opinion about the effect of that. So even I am also waiting for how this amendment is going to take place. Once the amendment will come into force, then I will be able to answer. But right now, I'm not able to answer that particular about that particular amendment.
Because the amendment, only this combination portion has not been still notified by the commission. Though they have come up with the draft regulations and they have seek a public opinion on those draft regulations on 25th of September, by 25th of September. So just was looking for what's your opinion on that thing.
See, I would say any change in merger regulation is good, because as far as we are concerned, we are all talking theoretically. Even I am also talking theoretically. What is actually happening in practical sense? What are the practical issues? That is best known by CCI. And this amendment is proposed by the experts. So definitely that amendments are having a value. That's what I believe. So I'm not going to criticize that amendment.
Yes, so one good thing which they have, one good thing which they have did that now they have reduced the duration from 210 days to 150 days.
That will also, even that 200 days also will be dispelled with.
Yes, sir.
Definitely that will be removed, because this green channel approval is there.
Yes, sir.
Through that, you will be able to go away with that 210 days. Even interestingly, this 210 days is also not applicable if you go strictly by the practice, because section 6 clause 2 says there has to be a pre-merger notification. Now this 210 days is applicable only with respect to that 6 clause 2, but that is now suspended. So up to 2027, there is no need of waiting for 210 days. If you are confident enough, your combinations will not have any adverse effect on market, you can directly go for merger. No issue. No need of waiting for the approval.
And there's a second question which I have related to the same topic. We have seen that during the insolvency and bankruptcy process, we have seen that company being acquired, like the Tata Steels has acquired the Bhushan Steels, or the other groups have acquired the other groups. Whether those acquisition in an CIRP process is also going to fall under the domain of a combination, and henceforth an approval of CCI is required over there.
Yes, that's what I raised the issue of a tussle between sectoral regulators. That is a sectoral regulator you are talking about. If that acquisition satisfies the threshold limit prescribed under Section 5, definitely CCI can investigate.
No, sir. CCI will
definitely CCI can investigate.
Anyway, CCI have a power to investigate all the transactions. And that too, after the Amazon judgment, they have also exercised their power with the retrospective date. But my question was, is it like, because as soon as the threshold limits attracts, there is a mandatory disclosure which need to be made by the parties. So what I am putting that once an acquisition is taking place under the order of an NCLT, under the scheme of CIR, on a process of a CIRP, even that time also do we need to take the approval from the commission, means we have to wait for 210 days. And in between, the interest of the creditors under an IBC process may jeopardize.
Exactly. Because see, IBC process will take care of the interest of the parties involved in. in a different way. They are
Correct.
not looking at what impact it will have on market. Okay, but when it comes to competition commission, they are looking at only the issue of effect on market competition. So CCA will interfere, no doubt in that. You cannot go away from that.
So, sir,
Okay.
like another third related question: do you believe that we need to have a merging of these independent sector regulator into one regulator, so they can work together if this type of transaction comes?
No, it's not possible. It's not possible. It's not possible.
Okay.
See, it will be like our Supreme Court then. See, these are all technical matters which need technical expertise, technical assistance.
All right, sir. Thank you.
Hello. Yeah, thank you. Thank you for the valid questions.
Thank you.
Any other question?
Sir, I have one question.
Yes.
I really want to know about this extra territorial rights that has been given. I mean, I really don't get the exact idea about the extra
It's
territorial
not
rights.
audible to me. Can you make it?
Am I audible now?
Yeah,
Hello?
it's okay. Continue.
Okay.
Yes,
So
ma'am.
can you please throw some light on the extraterritorial rights that has been given? Means how in what way we the CCI use those rights? I mean, I need to know the
Yes.
practical approach of that.
See, Section 32 of our Competition Act. Okay. Section 32 of the Competition Act empowers CCI to investigate about anything which happens outside the country. Hello?
Okay, sir. So, as you said, the government of our country and the other country, they do a kind of a extradition sort of treaty with the perspective of these rights, or do they have these separate rights with the perspective of the CCI?
No. See, Section 18 provides functions of CCI or duties of CCI. Section 18 empowers CCI to enter into MOUs with other countries, the corresponding competent agencies of other countries. Say, for example, Indian Competition Commission makes an agreement with in England, the CMM, Competition and Market Agency there. Then, whenever Indian Competition Commission wants to regulate something in England, they can act through CMA. So, Competition Commission having the authority, and they have already made this. I think around 20 countries or something already they have entered into MOUs with 20 countries. It's available in their website.
Okay, got it, sir. Sorry, I am a very beginner as far as concerned to this subject, so I have a very, you can say, a kind of
No,
a
no,
question.
it's a good question. It
basic
is a good question.
Thank you. Any other question?
I think no more questions. So thank you, sir. Thank you, Dr. Pillai. Such a, I can say, a very substantial and exhaustive session. And you brilliantly highlight the horizontal merger or the vertical merger. And even you gives us the idea how we can teach, as you tell us about section 6, section 20. So the beginners like me, they really get a particular idea how we can start this subject, how we can go about it, and how we can teach. As I am a very newcomer as far as concerned to this subject. So thank you so very much, sir. And
Thank you.
Any other question? The platform is still open.
Not a question, Harshita. I just want to say thank on behalf of Amity Law School, and I just request to our chairman, Dr. D.K. Bandyopadhyay, sir, just say a few words and greet the guest, our Dr. Anish V. Pillai. Chairman, sir, may I request you, sir?
Anish ji,
Yes,
I
sir.
could not listen to your lecture, in greater details, but whatever I could listen that, it indicates that you have a thorough understanding of this concept of the merger and acquisition and the related sections of the Competition Commission. But many times it has been seen that company do acquire another company, and they acquire them with lock, stock, and barrel. And once they do that, then that the previous organization culture, previous organization way of working, and the new organization structure, new organization processes, it creates a tremendous amount of pressure on the part of the existing employees. So is there any rule or regulation available under the CCI how to protect the interest of the employees of the acquired companies?
Sir, sorry to say that that is not investigated, or that is not a matter of a competition law. Competition law will not look into that type of aspects. That will be looked at by company law and the concerned sectoral regulators. Competition law will see, because of merger, whether that merger will have any adverse effect on competition in the market. So only with respect to how it is
essentially
going to
it will
affect
have an adverse
competition.
impact, because if the employee do not work and the previous company, the way they are functioning, and employees are not working, essentially it will have an indirect influence on the competition.
Yeah, in that level we can say, but still CCI won't directly look into that. Maybe while examining the criteria of identifying appreciable adverse effect,
because the
they will
210
consider
days
this.
what they give before acquiring a company, they essentially need to look into all aspects, all dimensions of the acquisition.
Right.
Otherwise,
right,
they will
right.
be giving a great injustice to the
Correct,
acquired organization.
Correct, sir.
And
Correct,
that's
sir.
just, I wanted to have your comment. I mean,
Yeah, that's what you're saying is correct. I agree with that. But still, CCI as a entity or as a regulator, they will have the primary focus on competition. Whatever aspects will adversely affect competition, they all will cover. They all will be looked at by the CCI. So in this way, the way in which you said, if it is going to affect competition in the market, definitely CCI will take care of that. Because what is going to affect market competition, nowhere it is mentioned. That is all will be revealed through identification by CCI.
because it has created many, and at least I know that 2-3 case studies. Example of the Kelvinator and the Whirlpool acquiring the company and merging them together, and the type of chaos it created, and within the organization. As a matter of fact, that Whirlpool competitiveness essentially got jeopardized in some extent. I'm talking about this case, in the early 2000. So the case amply exemplify that possibly when this question of acquirement came or acquisition came, that nobody was there to look into what type of acquisition going to take they are going to take, because it was the acquisition of lock, stock, and barrel. Now, how the market is going to feel about it, how the market is going to accept it, how the competition level is going to be there, whether this merger is going to create another new problem. I think this is the responsibility. Don't you not feel that Competition Commission must look into before allowing for the merger, for the acquisition merger?
Definitely, true. That's true. I agree with that. That's what I said. There is no hard and fast rule. CCI will not look into that. Only question is, it must have some connection with market competition. That's it.
So thank you very much. You are sitting at the another corner of the country near the Arabian Sea, and we are sitting in the hot temperature of Delhi, but we are able to communicate with each other. We are able to see each other. That's the most important thing. And we are thankful to you for coming over here and giving your inputs and giving enough clarification about the merger and acquisition of the different companies, and which comes under purview of the Competition Commission. So I, on behalf of the Amity Law School, Noida, I actually thank you very much, and also look forward for such type of interactions, maybe virtually, maybe physically, because I all the time believe that physical interaction is better than the virtual interaction. Because virtual interaction means, many types of questions. I think many persons are hesitating to ask the question because they're in virtual mode. So they do not know in which type of dresses they are wearing, what type of things they are doing. So they don't want to open their camera even. That I could see that they were listening, but they are not opening their cameras. So this type of hesitancy, it takes place. So I look forward for your, visit to our, law school whenever you are in Delhi. Please do let us know so that we can invite you to come to the campus, and we'll have a much more better interactions, because our group in the area of competition, we have a competition law course, and some group is working. They are also writing some articles, and it will be great to collaborate with the Cochin Law School, and that will be, I would say that the true spirit of academic, academic progression. That's because it is a faculty development program. We are trying to progress them. Academic progressions, we have to make them so they are to be educated about this, because it's a new area, new field. And although it's a little bit older, but nevertheless, still it has not been that much of focused, but this is going to be more and more focused areas. So in that context, getting the inputs from the person like you, the participant, we have got about 45 participants. They are going to be highly benefited. So thank you very much on behalf of the Amity University, on behalf of the Amity Law School Noida, on behalf of our Honorable Founder President, Chancellor, and Vice Chancellor, for taking your time to come over here and deliver this talk for the benefit and the cause of education, law education typically. So thank you very much. Thank you, Garima, and thank you. वो कहाँ चला गया? हर्षिता कहाँ गया?
Sir, I am here. My camera is still open.
ये कैमरा तो दिखाई नहीं पड़ता है.
So thank you so much for
and also I must thank Dr. Tomar, who actually took the initiative for having this program, talking to the Competition Commission, bringing the experts like you, and then having a fruitful deliberation and develop the great narratives. So thank you very much.
Thank you, Anishji. Thank you very much. Thank you, Chairman.
for giving me this wonderful opportunity. Thank you.
Thank you, Dr. Pillai. Thank you so very much, sir.
Thank you.
So on behalf of Team FDP, sir, I would like to express our gratitude for your participation as a guest speaker in our event. And your contribution to the success of this session was immeasurable, and we hope to have the opportunity to work with you in the future. And I also would like to thank Chairman of Amity Law School, Dr. D.K. Bandyopadhyay, sir. Thank you for joining the session today. And this brings us to the end of today's session, and I would hope to see you all in the next session. Thank you very much.